Good afternoon to you all. Thank you all for joining us in the first ever virtual regional conference on decriminalization of petty offences in Africa. To all our participants who have joined us today, kindly note that this conference is being interpreted into the French and Portuguese languages. To choose your preferred language, you will click on the global icon at the bottom of your screen, then click Mute Original Audio and select the language which you prefer to listen to the conference sessions with. I now wish, without further ado, kindly allow me to invite Abdul Nur Mohammed, the Executive Director of the International Commission of Jurists, the Kenyan section, to open this auspicious conference for us. Welcome, Abdul.
Honorable Maria Teresa Manuela, Commissioner, Special Rapporteur on Prisons, Conditions of Detention and Policing in Africa, Mr. Tem Fumbu from the Open Society Initiative for Western Africa, and distinguished guests, good afternoon. On behalf of the Regional Network on the Decriminalization of Petty Offences, it gives me great pleasure to welcome all of you to the 2020 Regional Conference on Decriminalization of Petty Offences in Africa. The theme of this three-day conference is Criminalization is not a public health response. Notably, this conference is being held at a time when the global community is facing an unprecedented crisis, one which has been termed as a defining global health crisis of our times. The COVID-19 pandemic has tried and tested our criminal justice systems and structures, and required us to adopt to a new normal. This conference will mark the first ever regional conference on the decriminalization of petty offences in our continent. It is worth noting that African states have employed extraordinary measures in a bid to reduce the spread of the virus and at the same time minimize its impact. The pandemic has adversely affected the socioeconomic, legal, and political order in the region and has spiraled into a human rights crisis, one that has exposed existing inequalities within our countries. The pandemic has magnified the existing structural, institutional, policy, and legislative weaknesses in our criminal justice systems. Now, this calls for a multi-sectoral approach to reforms. The success of this reform agenda lies in our ability to change discriminatory laws and policies, and also remold the negative public attitudes and perceptions toward reforming the criminal justice system. ICJ Kenya wishes to sincerely commend the African Commission on Human and People's Rights for adopting the principles on the decriminalization of petty offences in Africa, a resourceful guide for states that will guide them in building a robust criminal justice system which responds to the needs of the minorities and vulnerable groups. Lastly, I wish to applaud the partners within this regional network on the decriminalization of petty offences in Africa for successfully planning this conference and advocating for criminal justice reforms and pushing it to the forefront of this regional conversation. I welcome you all to this conference and wish us 3 days of fruitful deliberations. Welcome.
Thank you, Abdul, for your remarks. I now wish to introduce Mr. Tem, to invite Mr. Tem from the Open Society Initiative for West Africa to make his remarks. Welcome, Tem.
Thank you, Joan. Thank you, everybody. Good morning, good afternoon. I present these remarks on behalf of 4 Open Society Foundation's entities: the Open Society Human Rights Initiative, the Open Society Initiative for Southern Africa, the Open Society Initiative for East Africa, and the Open Society Initiative for West Africa, who are all very proud supporters of the incredible work that the Campaign for the Decriminalization of Petty Offences in Africa has been doing. I want to particularly recognize and appreciate Commissioner Maria Teresa Manuela, the ACHPR Special Rapporteur on Prisons, Conditions of Detention and Policing in Africa, for all her support and commitment to this campaign. From very modest beginnings, this campaign has witnessed exponential growth moving from work with only a handful of partners from the beginning to more than a dozen today in all four corners of the continent. The growth is explained not only by the pertinence of the challenges posed by petty offenses, the enforcement of petty offenses laws in Africa, but also by the zeal and drive of the various campaign partners to alleviate the plight of the many victims of petty offenses laws on the continent. I take this opportunity to express our appreciation to the African Policing Civilian Oversight Forum, APCOF, and all the campaign partners for tenaciously driving the work of the campaign, even during this very trying moment. As Abdul mentioned, this conference is taking place at a very peculiar time in history when we are witnessing unprecedented struggles against the legacies of slavery and colonialism, and in the midst of a very devastating global pandemic. The existence of petty offenses laws on the continent is one such legacy, and it is important. It's very important that we seize this historic moment to push for equality, accountability, and the recognition of the humanity of us all, not just of some of us. Also, the COVID-19 pandemic is another unprecedented moment, which not only exposes the perniciousness of criminalizing life-sustaining activities, but further entrenches the marginalization of millions of persons who are already struggling from the legacies of failed economic, social, and health policies. As countries struggle to contain the pandemic, they have gone back to the familiar pattern of using criminal law to solve complex economic, health, and social crises. As a result, the criminalization of these life-sustaining activities has taken on a new vigor during the pandemic, which has led to increased arrest for petty offenses. But as perverse as it might sound, the pandemic validates the relevance of the work that we've been doing in the past years and presents offenses to the next level. It has also shown that large-scale releases of petty offenders do not pose any imminent risks of lawlessness and insecurity in our communities. And of course, this directly contradicts the stated purpose of the many arrests for petty offenses, which are justified on the grounds of order and safety. It is our hope that at the end of this conference, we'll come up with new strategies and best practices to respond to the pandemic that are rights-based. As we deliberate in the next 3 days, I want to assure you of the continuous support of the open society entities that have been with you from the very beginning. And we assure you that we'll continue to provide this support. I thank you and we wish you fruitful deliberations in the next 3 days.
Thank you, Tem, for your remarks. We are grateful for the continued support and partnership that has been availed to the network by the Open Society Foundation. Now, kindly allow me to invite Commissioner Teresa Manuela, the Special Rapporteur on Prisons, Conditions of Detention and Policing in Africa at the African Commission on Human and People's Rights. She has been instrumental in advocating for decriminalization of petty offenses in Africa and making this dream a reality. Welcome, Commissioner Manuela.
Muito obrigada, Joana. Boa tarde.
Thank you, Joanna. Good afternoon, Abdul. Good afternoon, everyone. I need to greet all the ladies and gentlemen who are present in this room. I hope that we all started our day well and that we are in this meeting with a good understanding of the situations, just like my co-organizers mentioned. And we hope that this epidemic cannot be a reason for us to stop doing the work that motivates us, which is to protect human rights, in this case, and concretely, to support those who are most underprivileged in our countries, and to fight against the criminalization of petty offenses. I need to say that to all wish to welcome all of you on behalf of the African Commission on Human Rights, and to say that our commission is committed to convince and to prove to the states that these small offenses, these actions can be resolved in other ways, and that it is possible to bring, and without disrespecting anybody's dignity, just to know that, to understand that some people are more vulnerable. And just Ms. Abdul said, with this pandemic, we've seen situations which are very disturbing, and we are seeing gaps, and we're seeing some parts of society which are more affected, and so the responses that the government can have not been the best. We have not had the best responses from governments, and so we need to. I need to say that I hope that the exchanges that we're going to have will be able to provoke interest from the African states, which are parties to the Charter. So in order to implement a review of the standards of criminalizing standard conducts, which are not very serious, which lead people to go into prisons, and which is a violation of their very elementary basic rights. In our Commission on African Human Rights, and together with our partners, putting together this webinar, we are convinced there are alternatives, and some good alternatives that we are suggesting. And I hope that at the end of this conference of 3 days, that we are going to we will be able to convince, present our positions in a much better way, positions that the governments and state parties need to take into consideration. That we'll be able to present facts which can be considered, which can be implemented, and so we look for having a possibility of having decriminalization. And so I'd like to say welcome to each and every one of you, and thank you very much on behalf of the African Commission. Thank you so much for the opportunity to be here. Thank you once again.
Thank you, Commissioner Manuela, for your remarks. Before we delve into the subject of our discussion today, I wish to remind the participants who are currently joining us that the discussions of this session are being simultaneously interpreted into the French and Portuguese languages. To do so, choose your preferred language by clicking on the globe icon at the bottom of your screen, then click Mute Original Audio and select the language you want to listen to. Also, I would like to bring it to the attention of our participants that we will be availing a Mentimeter or a quiz, and we kindly request you to participate by submitting your responses as they will largely inform our discussions. Now, without any further ado, kindly allow me to invite the moderator of our next session, Mr. Luke Muting from the African Criminal Justice Reforms Organization. Welcome, Luca.
Good afternoon to everybody, and it's indeed a good occasion to see so many people participating in this first day of the seminar. My task is to moderate this first session, and a couple of things I do need to bring to your attention, but let me first just give you a brief overview of what will happen in the course of this afternoon. We will have 4 presentations covering the 4 regions: Southern, North, East, and West Africa. And we'll kick off with Southern Africa with presentation from Janelle Mangwanda and Kristen Peterson from Africa Criminal Justice Reform. And then we will move directly north with a presentation from Ragheb Zouawi. I hope I pronounced that correctly, from Avocats Sans Frontières. Then to the east with a presentation from Judy Mateka from the International Commission of Jurists, Kenya. And then to the west with a presentation from Ogechi Ugo from Prawa. So a warm word of welcome to our presenters, which I must also bring to your attention is we're running a tight ship in terms of time. So I do ask you to please stick to your allotted time schedules. That is 15 minutes per presentation. We will also, in the course of the afternoon, have from Joanne a presentation on the outcome of the Google quiz, or the Mentimeter, as you've already heard. And we will have a time and question session that is scheduled for around about 3:45 South African time, or 2:45 GMT. And please, if you have any questions, put them in the chat box, and then we can work through them one by one. And then Abdul Nur Mohammed will do a wrap up of the day for us right at the end. So I've also been asked to bring to your attention that there is a campaign statement in the making. There will be a link to a Google Docs, so you're all very welcome to make inputs on the campaign statement. So our session for this afternoon is about balancing rights in the context of petty offences, but I think COVID-19 has also brought a new dimension to it. So I want to make a few, a total of 4 points. I've just been reminded or informed that Commissioner Manuela needs to make a presentation. Does that mean I am being interrupted here? Can we give the floor to Commissioner Manuela, and then I will pick up where I left off?
Obrigada, Sr. Luca.
Thank you, Mr. Luca. Thank you for once again giving me, thank you once again for this opportunity for this organization. It is my duty to, I have a special duty to work with our partners, and it's important for us to allow Portuguese-speaking countries to participate in this debate, not just to go with the normal flow. I just have to say that it's an honor for us to also participate. Let me just time myself here. It's a pleasure for me to be part of this conference organized by the African Commission, as well as our partners of the local campaigns on the fight against the decriminalization of small petty offences. I need to present a basic principles on decriminalization. The Commission adopted these principles in October 2018, and these principles, we have article number 45, which presents these principles, and this article number 45 seeks to have the Commission to promote the human rights in order to have rules, in order to help resolve problems that are related to the human rights, and also to protect fundamental liberties. If I'm speaking very fast, please let me know.
Nova norma. Devagar, tá bem. Obrigada. Obrigada.
Thank you. The Commission adopted new standards because it was concerned with the fact that certain categories of people, including those who are very underprivileged, who are living with in a social condition, unjustly targeted, of being arrested and taken to prison for having committed small petty offenses. When these people are targeted by specific laws in this manner, that threatens the ability to enjoy human rights within the criminal justice system. In particular, the Commission was concerned at the fact that the existence of laws that could, in a certain way, violate the rights that are protected by the African Charter. For example, the non-discrimination in the second article, respect for the human dignity in Article 15, and the liberty and security of all people in Africa, which is also Article 15. So these concerns are the ones that the principles seeks to address and to encourage all African countries to abolish laws which could be categorized as petty offenses. These petty offenses, they're not serious. There are several offenses in accordance to the laws that we've looked at in several African countries. We have verified that to roam around, just to be idle, being disorderly, just begging and sitting around, not paying debts, and they make up inconvenience in public. To refuse to wash clothes, to be disobedient to parents in certain contexts. These are criminalized acts in certain societies. And so these actions are often punished punished by the police and by laws, community laws. And so for some reason, some people are fined or even taken to prison because of such actions. So the principle that we put together were to defend and to establish a comprehensive approach to deal with challenges that we do face in Africa, and in a manner that is interesting. Now, that is to say, we say that poverty and justice have a lot to do with human rights.
Os princípios pretendem dar uma resposta.
So, these principles offer direction to the states on actions that can be taken in order to protect the rights of these people at the point where many countries are dealing with poverty in their communities. And so they also establish standards so that petty laws, which are identified by the states, some of them, these laws are inherited from colonial regimes, which have not been changed. These laws need to be evaluated, need to be reviewed by the states, and so we need to promote measures to enable that laws do not target people because of their social status, not because of their status in society or whether they're poor or not. And there's certain activities that are subsistence people are involved in, and the success of these principles in the promotion of justice will be maximized if there is implementation by states which are part of the African Charter. That is our duty in our African Commission, and together with our partners, we need to monitor to effectively ensure that the nation states be able to understand these principles. It is important that states commit themselves to the implementation, and with stakeholder support, they can work together to ensure that the decriminalization takes place. And so that is why the Commission adopted these principles. We support a mechanism that will be able to review the detention conditions, and we seek to work with a lot of our partners, and so many, and some of them will be able to speak. We put together a simplified version of the principles in a document in order to enable easy distribution and an easy understanding. There's not a lot of text in this principle. There's no time to really read a book that has that we could put together in these principles. The principles are integrated in 6 parts, and there's a definitions of the terminology, the purpose, why the principles were presented, a description of the behavior which can be used to define petty offenses, and the probability of these behavior, the possibility of a violation of human rights when these people are punished, as well as the measures of the African countries can and must take in order to guarantee the protection of the African family. And as well as the incompatibility of petty offenses and their basic fundamental rights, which have to do with human dignity. Another incompatibility with of petty offenses with a right to liberty, and that is Article 6 of the Charter. And the last part, we put a proposal to decriminalize the petty offenses, and we propose that laws should correspond with the principles and regional standards which protect the citizens, and to deal with in a different way with these violations. And not to allow that it becomes a weight on those who really need those activities. For example, when you talk about hawkers on the streets, so that they can support their families. So the simplified version is also an effective opportunity that will allow the stakeholders to have a better understanding of the standards related to human rights, which were put together in this area. It's put in a very clear and simple language. The African Commission, we hope that the measures that we are putting together in this campaign in regards to the decriminalization of petty offenses, that the principles will be able to be translated in several local languages, so that like with the citizens, especially those who are the ordinary people in the communities, can have a better understanding of their rights, and they can have an understanding that that for them to understand that we can have a common good generated from all this, and that everyone, all of us, can approach a different attitude. Like when we had a meeting in Accra, when we had in the first conference, we say that we need to work, the states need to work together with these people so as to be able to empower them so that they can improve their behavior and to adopt new behavior that can contribute to the bettering of the society. Ladies and gentlemen, this version, a simplified version, was supposed to be presented in our next commission meeting, which was supposed to take place in July, but which took place on the 7th of August instead of July. Unfortunately, as a result of the epidemic, it was not possible to present, to launch these principles in our simplified version, because the session was done by a video conference. But we understand that the work that we're doing, that we hope that through this webinar that we'll be able to launch these principles, and that we will be able to probably be in a position to be able to physically launch these principles. I need to say that both versions are available in the African Commission's website, and all African citizens will be able to consult these principles so as to be able to go to this site and to be able to get an understanding of the content. And I'd like to take this opportunity to thank all my partners in this campaign on the decriminalization of petty offenses in Africa, for putting together this conference and for working tirelessly to guarantee that laws that criminalize small petty offenses are reviewed and changed. We're going to continue to work so that the sectors which are affected by these laws are empowered and raised, so that they can also feel we can work to improve Africa, and especially the social life in Africa. And I sincerely hope that all of us will find this to be useful, the principles that we put together, and that more African states will be able to implement these principles. We are going to consider we're going to launch this simplified version virtually on the decriminalization of petty offenses. I'm going to ask on behalf of our African Commission that all the partners continue to work together so that we can effectively spread these principles in all parts of Africa, because so that we can be able to reach the very last African, even those who are not able to speak English, French, Arabic, or Portuguese. Let's have it in Swahili. Let's have it in that are spoken in different parts of Africa, so that we can have these principles better consumed in parts of Africa. I'm very thankful, and I'd like to give back the floor to the moderator.
Shall I continue, Chairperson?
Pode sim, senhora.
Yes, sir. You may continue. Go ahead.
Thank you. Thank you very much to Commissioner Manuela for her wise words and encouragement, and we are always appreciative of the work done by the Commission in supporting human rights reforms across the continent. So I've briefly given you an overview of the program for this afternoon. I want to make a few remarks just to introduce the topic for this afternoon, because it is about balancing rights and looking at poverty issues, socioeconomic rights, civil and political rights, and see where we are going with all this in the context of COVID-19. So I think for many of us, the lockdown around COVID-19 came very quickly, and few of us, if any, were prepared for this. And not all states responded in the same way. And not all states were affected equally. And there was indeed a diversity of the responses to COVID-19. In the case of South Africa, there was perhaps some sense of relief that government is taking strong leadership in troubled times. And at the other end of the spectrum, Malawi quickly saw litigation, and the courts agreed that there was not yet a case to be made for a national lockdown. So from this, I want to make 4 points. And the first issue to explore is what was the process that resulted in the rules changing, in the rules that govern us? And how did government come to these conclusions? And what was government's own views and perceptions on how to handle the situation? More important, who did government consult in declaring the lockdown where it was so declared? And was it only done by the executive, or was there extensive civil society consultation, or consultation with the judiciary or other interest groups? So was this a true balancing of rights, or was there a domination of one set of interests over other interests? So that's my first point. The second set of issues that we need to explore is the substantive change in the rules and what was permitted and what was not. And this would then inquire if there was a rational connection between the new rule or the change in rules and the aim to be achieved. And was the state able to demonstrate that there was indeed such a rational connection? And furthermore, that this was the least restrictive means to achieve this objective. My third point then concerns the enforcement of the new rules. And that's probably the most visible that has been seeing in the media and on social media. And so the new rules and the new powers give rise to exploitative practices such as bribery and intimidation and even assaults. And in South Africa, we had no scarcity of that. If there were violations of people's rights under the lockdown, were these properly investigated? And were the rules applied and enforced in the same manner everywhere? Or were certain groups and individuals targeted for enforcement? And what recourse was there to those who felt aggrieved in one way or the other? And what happened to those people who were already deprived of their liberty? Those who are sitting in police cells or who are awaiting trial in prison. And I think following from that, we need to ask questions about how oversight agencies were performing. So we also need to look on the one hand how the criminal justice system, by means of the police especially, were mobilized on the one hand to limit movement and curtail certain rights. And on the other hand, how the criminal justice system was effectively brought to a standstill with particular reference to the courts to prevent the enforcement of primarily due process rights and the right to a speedy trial. In many regards, rights categories were now pitted against each other. And this placed us as human rights defenders in a difficult situation. My fourth and final point is then, what lessons can we take from this for the future? It is not impossible that we will see a repeat of what we've experienced over the past 5 or so months. And it may be a different virus, it may be a different threat. But we must therefore be vigilant about how rights and liberties were curtailed and how we got to that stage. And moreover, that we need to test our current legal frameworks to see how we have fared in the past 5 months. So with those remarks, I want to give the floor to our first presenters, Janelle and Kristen. I don't know in which order you are presenting, but you have the floor and you have 15 minutes, and I'll give you a 5 minutes left warning.
All right, thank you very much, Lucas. Greetings. And my name is Janelle from the Africa Criminal Justice Reform. And my presentation today will focus on South Africa's lockdown regulations. I will be tag teaming with my colleague Kristen, who will come after me to give us more insight on particular examples of how marginalized groups were impacted by lockdown regulations. But as we all know, like most countries in the world, South Africa established a state of disaster and implemented a lockdown in an effort to curb the spread of the coronavirus disease. The lockdown in South Africa began on the 26th of March and was stipulated to last for 3 weeks. It was further extended by 2 weeks, and during this time, unless you were an essential worker or needed to perform an essential service, such as buying an essential good or collecting a social grant or seeking emergency or life-saving medical care, citizens had to remain at home. So all schools and social spaces like bars, movies, and sports centers were closed. After the first 5 weeks, a 5-stage risk-adjusted approach was announced, which saw the implementation of a 5-level of lockdown, which came with varying degrees of openness of movement, as well as activities for the purposes of reopening and reviving the economy. The 5 stages, the 5 was the hardest form of the lockdown, and that ended on the 31st of April, after which level 4 kicked in on the 1st of May, and level 3 on the 1st of June, and level 2 began on the 18th of August. South Africa currently stands at level 2 of the risk-adjusted plan. However, there are talks that the country will soon be moving to level 1. So throughout the lockdown, a set of regulations were published through the Department of Corporate Governance and Traditional Affairs, which guided the activities and movements. In my presentation today, I would like to highlight how the failure to abide by the lockdown measures attracted strict punitive measures in the form of the imposition of fines and, in some cases, arrest and detention. In fact, these measures were particularly punitive, as many poor and marginalized people had to come face to face with law enforcement in the midst of their search for survival. In most cases, the police and law enforcement strictly implemented and interpreted the regulations without taking due considerations for varying degrees of reasons and backgrounds. In fact, the lockdown regulations have brought about new petty offenses which previously did not exist. For example, in the case of poor and marginalized groups, in April, 9 waste pickers were detained for 3 months at the correctional services in Pretoria for breaking lockdown regulations by going out to collect recyclable materials to make an income. For months, legal representatives were unable to consult with their clients to find out the details of their detention or the charges under which they were arrested. According to the legal counsel of 2 of them, this was a serious human rights violation to deprive someone of their liberty without justification. And he also said that it says a lot regarding the policing of poor people during a lockdown. Another example where the strict enforcement of the regulations took place was under level 4 of the lockdown, which was effective from the 1st of May, wherein people were only allowed to exercise between 6 a.m. and 9 a.m. within a 5-kilometer radius from their homes, but they were not allowed on beaches or on parks. A small Muizenberg family here in the Western Cape was arrested after their toddler ran off from the promenade and onto the beach and threw a tantrum. When her father went out to get the child, the police officers approached and subsequently arrested them. In his social media post, the father indicated that health and safety standards at the police station were appalling and many of the police officers were not wearing masks. Another example is that of a 71-year-old diabetic man who was arrested in Somerset for failure to confine in residence after he was stopped at a roadblock on his way to the shopping mall to collect his medical prescription and purchase food. When he was asked about his prescription, he explained that since it was a long-standing prescription, all his information was captured on the pharmacy system. The gentleman pleaded with the officers to use common sense and not penalize those who were legitimately making use of essential services. All these infractions have attracted fines and in some cases arrest and detention, which is counterproductive in the fight against the virus, as bringing more people to closed and oftentimes overcrowded detention centers increases their chance of catching the virus due to a lack of social distancing. As far as the fines are concerned, every major city had its own determination of admission of guilt fines in respect of the offenses in terms of the disaster management regulations. For example, in the city of Pretoria, failing to confine oneself in a place of residence attracted a fine of 500 Rand, which is about $30. The same with going to work without a permit or illegally walking and cycling. Illegally moving between provinces or metropoles would attract a fine of 1,000 Rand, which is about $60. All these enforcements have led to an increase in arrest and fines and unfortunately criminal records, although many people who signed admission of guilt forms are not aware that they attracted a criminal record. In May, the Minister of Police stated that almost 230,000 cases had been opened against people for contravening the country's lockdown regulations since they were first introduced. And in August, the figure was almost 300,000. The government is currently in discussions on how to deal with these criminal records, and the Department of Justice and Correctional Services is considering a bill which would allow minor lockdown offences to be discarded from the offender's criminal record. This leads us to a discussion regarding the rationality of some of these lockdown laws. Ladies and gentlemen, it is important to emphasize that not all the regulations were bad and not all the regulations were completely good. In June 2020, a Pretoria High Court judgment ruled on a case where it found that a number of lockdown regulations were irrational and disconnected to the purpose, but others were fit for purpose. In employing the rationality test, the court found that the declaration of a national state of disaster was rational because measures to curb the spread of COVID-19 were urgently required to convert an ailing and deteriorated public care system into a state of readiness, which was able to cope with a previously unprecedented demand for high and intensive care facilities. And according to the judgment, some restrictions did pass constitutional muster, including those pertaining to education, the prohibitions against evictions, initiation practices, the closure of nightclubs, fitness centers, and the closure of borders. However, on the other hand, with regards to some of the other regulations, according to the presiding judge, it can hardly be argued that it is rational to allow scores of people to run on the promenade, but if one sets foot on the beach, it will automatically lead to rampant infection. Another interesting comment made by the judge was in relation to the regulations relating to funerals and hospital visits. The court held that it is not rational that when an ailing loved one requires support, their family members are restricted from providing that support. However, when the person passes away, then 50 people who obtain death certificates are able to even cross borders to attend the funeral of the person who is no longer there and can no longer benefit of their support. The rationality test requires an evaluation of the relationship between the means and the end, and it is not designed to determine whether some means will achieve the purpose better than others, but only whether the means employed are rationally related to the purpose for which it was conferred. In its judgment, the court expressed that during a pandemic, the government should never lose sight of basic human rights. In fact, it should prioritize their realization and protect human rights in such a time. The Bill of Rights has not been given effect, and the pro-human lockdown would have perhaps looked much different. This case highlights the delicate balance required in policy making and in the process, particularly with regards to ensuring that fundamental human rights are not disrespected, but rather that they are respected and upheld. And this case shows us that where government actions do not satisfy the rationality test, their encroachment on and limitation of fundamental human rights, even during a pandemic, may not be justifiable. I will now pass on the baton to my colleague Kristen, who will delve a bit deeper into the aspect of the impact of the regulations on marginalized groups and alternative measures that could have and should have been used in South Africa. Thank you so much. Kristen?
Thank you, Janelle. My presentation, as Janelle mentioned, will provide you insight as to how the regulations have had an adverse effect on the poor and marginalized, with a focus on street vendors and the homeless in South Africa. Before I proceed with my presentation, I will show you a video of depicting South Africa's lockdown.
When police and the army descended on Dobsonville on the 23rd of April,
Kristen, we can't see the presentation.
Okay. Sorry about that.
When police and the army descended on Dobsonville on the 23rd of April.
We can't see the presentation.
Sure. Okay. I'll play it afterwards. Sorry about that. So I'll try to play the video after my presentation. So the government introduced various regulations, and this has had an adverse effect on the homeless and particularly street vendors. With regards to the homeless, the lockdown regulations make reference to homeless people being housed in shelters. Whilst we commend the government for providing these measures to allow homeless people to isolate during COVID-19, the implementation thereof has been dismal and left some homeless people in a worse position than what they were before. Some of the concerns or reports that were out in the media were that the homeless were rounded up and forced into shelters without their consent in certain towns or certain parts of the country. According to the regulations, for the period of the lockdown, anyone refusing to evacuate from any place subject to the lockdown may be evacuated by an enforcement official to a temporary shelter if such action is necessary for the preservation of life. And it seems as if the police were strictly applying this provision on homeless people. There were also reports that some homeless people were being fined for not wanting to isolate in such shelter or quarantine facilities. When news about these problems surfaced, the government or certain governmental departments backtracked and noted that homeless people were not being forced to isolate and they needed to voluntarily submit themselves to these facilities. The other concerns were that some of the conditions at the shelters were criticized for having deplorable conditions. Doctors Without Borders, an international NGO, their teams assessed several temporary shelters for the destitute and homeless in Cape Town, Tshwane, and Johannesburg, and found poor infection and prevention controls in all. They reported that these conditions actually placed the homeless and destitute at increased risk of contracting COVID-19 and other infectious diseases. One camp in Cape Town has been condemned as violating international humanitarian standards, and that at this camp, the Human Rights Commission was denied access to the shelter. The conditions were so bad that the High Court had to order the shutdown of the shelter due to its bad conditions. This is an example of how already marginalized and vulnerable groups of people were placed in further vulnerability and destitution by placing people in overcrowded tents with insufficient access to decent food or sanitation services. The other vulnerable group that was adversely affected by some of these regulations were informal traders. They rely on selling goods or their services, and this was gravely affected due to the fact that due to the lockdown and they were forced to stay at home. So at the beginning of the lockdown, the informal economy was unable to continue business. Only stores could remain open, and those stores those were stores that were providing essential goods or services. And mainly larger corporate grocers benefited from it. Unfortunately, during the lockdown period, we saw the rest of lots of street vendors operating during the lockdown period where they were not allowed to trade, or when the lockdown rules were regulated, which made provision for them to trade with a permit, they were either not having in their possession such a permit, and they were either not aware that they needed to have it or did not know how to apply for a permit. The problem is that many people were arrested and detained for such violations, which were counterproductive to achieving the purpose of curbing the spread of COVID-19 measures. So they were arrested for non-violent and minor infractions. The police enforcement measures were disproportionate and inappropriate. And one of the videos that was going to be played would have illustrated to you an incident where an elderly lady that was selling acha, she was arrested without even having heard her side of the story. She was loaded into a van and released later that same day. So one of the other issues that came up during the lockdown was who is classified as essential services? What are essential goods? And during this period, we found that a lot of street vendors, particularly in the Cape Town area, they had to actually institute litigation in order for them to be recognized as street vendors selling essential goods or services. So that's one of the issues. And Janelle, my colleague, mentioned that the waste pickers were arrested, and whereas they should have been released on a fine, they also are rendering an essential form of service in that they are recycling items or going to recycled areas and then selling those goods in order to support themselves. So these are examples of how people were not considered as important. They were forced to choose between hunger and breaching the lockdown regulations, but no appropriate consideration was given to them to explain, or they were not even given the last chance or warning, and the enforcement was totally punitive. So I want to conclude in terms of dealing with this aspect of policing a pandemic. We do understand that a lot of the measures that the government put in place were important in order to spread curb the spread of COVID-19. But what we wanted to see in terms of policing measures is that the enforcement through arrest and detention for specifically minor infractions is an unacceptable way to deal with a public health problem. And having people go through the criminal justice system is counterproductive, and it exposes them to heightened risk of infection owing to unsanitary and overcrowding in police cells and remand facilities. What we wanted to see is that police should not have been enforcing a one-size-fits-all approach to fighting the virus, because this will just lead to absolute devastation amongst poorer and marginalized communities. We wanted to see the police having a more balanced approach when dealing with poorer or disadvantaged communities, understanding their plight, educating them about the virus and the reasons why adhering to the lockdown laws and regulations are important. And for example, where they are not in possession of a permit to sell certain goods, advise them on how to get it and warn them that this is the first time they'll warn them, and for the next time, then there will be some sort of consequence for their actions. But also bearing in mind that as a last resort and as for the most serious violations, arrest and detention should be considered, but not in such cases. So, and also in terms of the government's response is, in terms of the regulations that were enacted, we wanted to see the that governments prioritize poorer communities within regulations and consider them as essential in during certain aspects of the lockdown. The law enforcement should be trained accordingly, just to consider the socioeconomic circumstances of certain poor and marginalized communities before punitively enforcing measures. Thank you very much.
Thank you to Janelle and Kristen. I'm going to hand over immediately to Raghib Zouawi. We're going to take all the presentations and then have a question and answer session. So over to you, Raghib.
Thank you very much. Merci à vous. Bonjour à toutes et à tous. J'aimerais tout d'abord, si vous me permettez, remercier les organisatrices et les organisateurs de cette conférence dans ces conditions particulières. J'ai l'honneur aujourd'hui de représenter mon organisation qui est Avocats sans frontières Tunisie. Le titre de mon intervention, ou plutôt son sujet, se rapporte sur les mesures prises par l'État tunisien pendant la crise Covid-19 pour lutter donc contre la propagation de ce virus et leurs implications, ou plutôt leurs effets par rapport aux droits humains. Donc, comme vous le savez tous et comme mesdames l'ont signalé dans le cas de l'Afrique du Sud, la Tunisie a été touchée par cette crise sanitaire mondiale comme tous les pays du monde. Le timing peut-être a été différent puisque le premier cas en Tunisie s'est confirmé vers le 3 mars. Entre-temps, la Tunisie avait déjà pris des mesures de sensibilisation et de lutte pratique sanitaire.
Just excuse me for a second.
Yes.
Where are the interpreters?
I am on the Portuguese side. Can you hear? I'm translating towards Portuguese.
I'm looking for English.
Oh, French to English. Ben, Eric. Voilà, ça s'il vous plaît. On attend interprétation vers anglais, s'il vous plaît, un instant. Ben ou Eric. Mr. Lucas, are you able to hear the French interpreter? French to English?
No.
Okay.
And the microphone, I can see the microphone of the interpreter is silent.
Ben or Eric? Made to understand that the participants need to mute original audio. Select English on there's an icon that allows you to select Portuguese, English, or French. If you click on English, you'll be able to hear the French interpreter interpret towards English. I don't know if that helps.
Yeah, no, my settings are correct. Is there anybody else from the panelists, the organizing committee, who's having the same problem?
Yes.
Oh, somebody else. Monsieur, vous pouvez essayer de continuer comme ça. Essayez, s'il vous plaît.
Is the interpreter ready?
Eric says he is ready.
Okay, please proceed.
Oui. S'il vous plaît, oui.
Quelque peu particulière, puisque il y a juste moins de 9 ans, en Tunisie, il y a eu une révolution, celle du 14 janvier 2011. Donc, la situation politique, économique et institutionnelle du pays n'est pas encore aussi stable qu'elle devrait l'être, surtout en face d'un danger sanitaire aussi crucial que celui du Covid-19. Donc, on pourrait certainement dire que l'ordre politico-juridique tunisien souffre toujours de lacunes fondamentales. On pourrait notamment citer des lacunes normatives puisqu'il existe toujours des normes juridiques aussi bien législatives qu'infra-législatives qui sont contraires à la Constitution de
Sorry, could I
2030.
interrupt again, please? We are still not getting the French to English translation.
Nous n'avons pas encore traduction vers anglais. Pas encore.
The Portuguese works. That's not the.
Hello, this is Ben, interpreter 2 on English channel. Are you hearing me?
Yes, now I can hear you.
Could be my colleague, the other interpreter to English, has got a problem with the microphone. I'm requesting him to stop so that I continue from this end.
Okay, excellent, thank you. Okay, let's proceed. Let's see if this works.
Is it working now, or you are going to request me to wait a little bit? This is the speaker asking. For our context,
please proceed.
Tunisia. For the general context in our country, when we saw this pandemic of COVID 2019, as I said moments ago, we have normative gaps and legislative ones that make the situation to be that the constitution that we put in place in 2014 has not implemented completely because we have some gaps which are supposed to have been dealt with from June 2014. There is some sort of confusion regarding power in Tunisia, the power, which parliamentary power, which is not very clear as it's supposed to be done. And then we have political gaps as well, because Tunisia, in September, October, we had elections, presidential and legislative elections, and the majority of these at the parliament, we have a good mixture of representatives when it comes to political representation. So in the economic aspect, we have a crisis as well, which is there for many years, which is characterized by inflation and employment. To that, you can add the weaknesses of administrative aspects when we talk about public health. To the south part of the country, for example, center west, we don't have a lot of capacity for the whole country. So for COVID, it was really a big task to the government and the government in general. So some measures were put in place in a successful way since the first case was declared, and even before, because the 2nd of March 2020, amongst the measures that were put in place, I could talk about restrictions of liberty of movement. Some restrictions were put in place, be it at the international level or national level. International in the aspect of closing the borders, airports and seaports from the 4th of March. And there was a decision which was really necessary, that was fruitful, but it was taken a bit rapidly or very fast manner. Calling upon those ones in the diaspora, the Tunisians. So it was not very clear. If I cite the example of 60,000 Tunisians who found themselves in Libya, locked down there. That is why you can see they were not allowed to come in. And this called upon the intervention of the army so that these people can be restricted. Then there was a national restriction of non-movement, which was able to see a lockdown, really, a curfew, which was declared by the president in line with the Article 80. So normally it's the Constitutional Court that is supposed to give guidance on these matters. But we found ourselves in a situation of silence because the executive power found itself to do the interpretation they wanted of what is supposed to be done, based on a very ancient democracy, I could say, what we are applying in Tunisia. For human rights, this restriction of movement had an impact, especially the rights to work, because all the population don't have a contractual employment. So they found themselves in a very complex socio-economical aspect. Vulnerable populations, migrants, for example, the Tunisian nationals who are under the threshold of poverty. So we had foreseen social aid of $200 a month to be given to these people, but they were not given because these vulnerable populations need to pay their rent, to give their families something to eat. So these restrictions had a very big impact on them when we talk about their liberties. So naturally, this is linked to the restrictions of movement. We haven't had demonstrations, associative work, when we see what the pandemic has brought around. The legal aspect, the 25th March, a student was arrested to have written on his Facebook page to have criticized the silence of his municipality. 1st April, a journalist was detained. We are talking about here of unclear circumstances. But this is linked to fundamental rights when we talk about liberty of association and the freedom to demonstrate. So populations were limited, really, during this crisis. People didn't have equity in terms of justice. And of course, all these came around with health impacts. Courts were closed, given that people were not supposed to move around. And naturally, this brought about with it the people not accessing justice system. And cases were adjourned to a later date which is not very clear, which was not defined in a practical way. And other people saw that their detention was extended.
S'arrêter cette crise sanitaire.
And people didn't know when the pandemic could stop. We opened courts the 8th of August. The ministry responded very fast, responding to the calls from the civil society. Because since April, when courts were closed, the civil society really thought that they've got to reopen. Of course, we saw courts working using online services. So this is a very good step because this comes at the time that we are we are trying to digitize the system because the citizens have got to get their rights. Other measures that were taken on board, there was the presidential amnesty, which was pronounced on different dates, 20th of March, during Eid, 5,000 detainees were released. This is an historical aspect in our country. Something like that hasn't happened. We could add to these measures for the measures taken by the government. The government saw it necessary to see that there is electronic surveillance, which could reduce the number of detainees, which are about 40% of those people who are in the government's hands in prisons and other detention areas. Even if these measures were not really very clear to the respect of private life, because the accused didn't have any guarantee regarding their private life. The head of government, in a televised interview, spoke about this electronic surveillance. And this really brought about a lot of outrage from the civil society organizations. In conclusion, I could say these measures were necessary, but they could have been put in place with respect to human rights. Of course, the government and the state in general had to see that they had a balance, not just a crackdown, because there is not a lot of transparency on what was put in place as a measure. Nothing was shared with the civil society organization so that they see it's clear. This is what is supposed to be done. The media was not put on board as well to understand what was being implemented. There was the absence of a participative approach because the civil society was not there and the general citizenry was not there to be informed on what was supposed to be done. Of course, the civil society was informed what is supposed to be done. Of course, I could talk about security measures, because we saw a lot of imbalance.
Le retrait également d'environ 1500 voitures.
1,500 cars were held for around 15 days for a reason or another, which was not very clear. The government is supposed to have lifted these measures of lack of movement for the people. But I must thank the organizers for organizing this meeting. I thank you very much indeed.
Thank you very much for your perspectives from Tunisia. I think it was very informative to all of us.
Merci beaucoup.
And I would now like to hand over to the East of Africa, to Julie Mateka from ICJ for her perspectives on state responses to COVID-19 and the socioeconomic impact of those responses. Over to you, Julie.
Thank you very much, Lucas, for this opportunity to present on this very important topic. I am coming to you live from the ICJ Kenya House. Allow me to pull up my presentation. So, good afternoon, various guests, panelists. My name is Julie Mateka. I'm a program manager at the ICJ Kenya. I wish to thank you for this opportunity to make the presentation on behalf of ICJ Kenya and the East African region on the social economic impact on the enforcement of state measures on the vulnerable groups and key population. I am very sorry to the translators because I spoke very fast. I will try to slow down. On March 2020, Kenya reported its first COVID-19 case. As at 13th August 2020, Kenya had recorded the highest number of COVID cases in East Africa with 36,157 cases, Uganda coming in second with 4,700 cases and a known number of infections from Tanzania. In Kenya, we have witnessed a great number of regulations that have come out during this period. The government response to this has been characterized by the enforcement of policies, legislation, and directives geared towards the minimizing of the spread of the virus. Some of these measures include limiting movement in places with reported cases, closure of public spaces with human traffic, schools and public events, dusk to dawn curfews, and ensuring basic hygiene and social distancing measures. In this period, the government of Kenya and state agencies have put in place 7 executive orders, published 7 gazette notices, and issued 14 guidelines, directives in response to the COVID-19 pandemic. However, the implementation of these orders and regulations have gone unchecked, and as a result, there have been a great number of human rights violations. The brunt of the impact of the enforcement of these measures has been felt by the vulnerable groups and key populations, most of whom live within poverty and overcrowded informal settlements. So I will go through various economic, social, cultural rights. I know that I cannot cover all of them, so I'll touch on a few that have become of great concern during this period. The right to health. The coronavirus pandemic has increased poverty, inequality, and unemployment due to its adverse effect on people's jobs and livelihoods in key sectors of the economy. In Kenya, we actually have a situation whereby it is more often that persons do not have health insurance as opposed to have. So the lack of health insurance for most of the people who reside in rural and informal settlements has worsened the poverty and inequality divide. Initially, the measures in place included mandatory quarantine for persons who are exposed to the virus. ICJ Kenya and other like-minded organizations filed a petition in court because of the adverse and rather gross human rights violations that were occasioned during the mandatory quarantine time. So we were in court challenging the measures in place, challenging the government directives on the issue, and also the conditions in which quarantine measures were being effected. The outcome of having such mandatory quarantine measures also led to people more or less moving away from going to hospitals to seek access to healthcare. So in this regard, you have people who then opted, especially women who are pregnant during this period, often opted to have and deliver their children in their homes, which led to an increase in maternal deaths during the COVID-19 period. Rights to livelihood and food security. Kenya is one of the few countries with a high rate of food poverty in Africa, which is interesting because it has fertile ground. However, the statistics towards that are very unfortunate. So during the confinement period, we have found that open air markets have been shut down as a containment measure, which means that imports and exports of food to be sold at those areas has also gone down. So this has greatly impacted the food security of most people in this country, with many people opting to just buy the food that is necessary for the family. So you have the fact that people do not have jobs, you have the fact that they need to eat. So many families and households have actually readjusted their budgets accordingly to ensure that the food that they do buy is necessary and not a luxury. On the right to housing, this has been a great discourse in our country because people living in poverty are finding it difficult to meet their daily expenses and pay bills, including rent. As a result of the various job losses that are happening and the pay cuts and the unpaid leave. So Kenyans, particularly those relying on casual work, are finding it difficult to pay rent. So data from the National Bureau of Statistics indicates that as at April 2020, 30% of Kenyans who rented apartments were unable to pay rent at the time. Conversely, 41% of the tenants paid their rent on time. So it means that indeed during this period, people are having great difficulties in paying rents. The reduced earnings and job cuts were mentioned by the respondents as the main cause of missed payment of rent. People living in informal settlements who are the most vulnerable and poor in the society have opted to travel back to their rural homes in order to live within the community and within their families because they cannot afford to pay rent within the society, within the urban society. We have also noted in Kenya that there has been reported cases of discrimination against the LGBTQI society, with many landlords using the ambit of the virus to also force evictions during this period, which has been a great concern to human rights organizations and issues that have been taken up in court. The right to gainful employment. During this COVID-19 period, a total estimate of 1.7 million jobs have been lost, greatly affecting the people who we serve and the people who are part of this campaign, particularly the waitresses who work in bars and restaurants. 3.3 million jobs are estimated to be lost at the end of the year if regulation is not put in place to counter the further regulation that was put in place, which said that social distancing in bars is not really working. So that has become a challenge as well. On the right to education discourse, this whole presentation is on economic and social cultural rights. So I have tried to touch a little bit in the few minutes we have, a little bit about every single issue on ECOSOC rights. So on the right to education, with the closure of schools, the right to education has been greatly hampered. A few months into the declaration of the pandemic, schools were officially closed, and most schools migrated into having classes on online forums such as Zoom. This posed a great challenge to the poor and vulnerable children who do not have access to these facilities, and further direction on which curriculum was being used to teach the children on these Zoom facilities and whether or not it had been accepted. So now we are in a situation whereby the right to education has been greatly hampered by the COVID-19 period. We do not have regulation on online curriculum, and unfortunately, even if we do have regulation on online curriculum, children from the poor and vulnerable will not have access to this right to education, which is therefore a challenge. I would be remiss if I didn't echo the sentiments of my South African panelists who have talked about the arbitrary arrests and the right to life which has been defeated during the COVID-19 period. We find that with the enforcement of regulation during this period, we have had a total number of 2,589 reported and documented incidences of police violence from April to May. So in 1 month, 3,000 persons were violated by the police. We have also seen that during this period, especially at the onset of the curfew regulations, 15 people lost their lives due to police violence because of the dusk to dawn curfew that had been imposed. And countless number of persons have unfortunately gotten life-threatening injuries. We also saw the growth of a poor economy, a corruption economy, because during this period, owing to the fact that the penalization of violating the curfew regulation was 20,000, bad officers, ill-willed officers of the law, therefore extorted Kenyans, extorted the poor and the vulnerable to ensure that if you want to circumvent the 20,000 Kenya shillings, which is roughly $200 fine, you then pay a bit and pay a bribe rather to get off. So we saw that as a negative economy that grew from the COVID-19 period. What are our recommendations? What are our thoughts around this? We believe that at the end of this, during this pandemic, and as we flatten the curve in most countries in our various, most countries around Africa, we need to call for investigation and prosecution of perpetrators of human rights violation arising from the enforcement of COVID-19 regulations by law enforcement agencies. We need to fund and we need to create commissions of inquiry on the distribution of funds allocated to cushion the vulnerable and minority groups from the adverse effects of the social economic impact of COVID-19. We need to take an active role as civil society to review the public health related laws and ancillary sanctions imposed for petty offenses with a view to decriminalize these laws and provide alternative sanctions. Across Africa, we saw that during this period, a lot of the countries through their prison systems were able to release a lot of petty offenders from the prison system, which therefore means, thank you, Lucas, which therefore means that indeed there is a way that we can have these petty offenses decriminalized. Indeed, there is a way that we can have most of the vulnerable persons who are within the detention centers removed from the detention centers. We also need to ensure that we have targeted support to vulnerable communities and groups and households so as to ensure that we cushion them from the crisis. In conclusion, whilst the imposition of restrictions on some rights in response to a public health emergency can be justified, the same must have a legal basis, be strictly necessary, and be based on scientific evidence. The laws and policies should not be arbitrary or discriminatory in their application. They should be limited in duration, respectful of human rights dignity, subject to review, and proportionate to achieve their intended objective. It is important for us to consider how every single law that is enacted has an impact on human rights, has an impact on the social economic human rights of persons who are marginalized and vulnerable and poor in the society. That is a small presentation of what has been the situation in Kenya. I do believe some of the things that we have raised are the same situations that are happening, rather the same situation that is happening in Uganda, and we will be able to discuss further in the question and answer session. I wish to give the mantle back to Lucas. Thank you very much.
Thank you very much. You actually have some 3 minutes left.
Lucas, please. Excuse me.
Yeah.
This is the interpreter. We are reminding speakers to go slowly. And to complicate things more, we are online.
Okay. Sorry, I was just spoken to there by one of the interpreters. If the presenters, we've got one presenter left today and some other inputs as well. But for the rest of our program, if we can just remind the speakers to talk slowly so that the interpreters can keep up and ensure that those who are understanding in a different language are able to follow your inputs. So let's move on now to our next presentation. which is from Nigeria, from Ogechi Ugu, and she's going to tell us about what happened in Nigeria around efforts to enforce alternative measures. Ogechi, you've got 15 minutes. I'll give you a warning at 5, and we look forward to what you have to say.
Okay, thank you. Thank you, Lucas, for the opportunity given to my organization for this presentation. I think I actually have a presentation that I need to be shared with me. Okay, I'm going to talk about Nigeria, what happened during the peak of the lockdown. So the topic is efforts to enforce alternative measures to address COVID-19 transgressions in Nigeria. My name is Ogechi Ugu, and I'm the Deputy Director of PRAWA. So I'd like to have my next slide. The slide is trying to give a kind of outline, but I think we can jump that to the next slide so that we don't waste so much time. So in this introduction, I am saying something that every other person knows, which is the fact that the COVID-19 pandemic took the world unawares, that many countries were unprepared, confused, and thoroughly destabilized by the rate of the spread of the infection, and especially the number of deaths recorded. As a result of this, there were desperate moves by countries to find a solution. And that resulted in what everybody is talking about today, using the justice sector to respond to a practically health challenge. So what we found ourselves in Nigeria doing, just like many other nations, was just the language of lockdown of cities. So the lockdown of Nigeria, at the point it was partial and up to the point it was total, had its social, economic implications on the people, especially those at certain strata of the society who were disproportionately affected. That is the poor in the society, those that earn their living on daily basis. Now, Nigeria recorded its index case of the coronavirus on 21st March 2020. So some of the things that happened was health protocols were developed to respond to this and curb the spread of the virus. Then fundamental to this was what every other nation was doing, the social and physical distancing, which actually led to the restriction of movement. Now, there was public awareness, though we cannot say for sure that this was robust, because in the grassroots area, many people were not really informed of what was happening in good time. Then there was the lockdown of cities and restriction of movement. Then the making of regulations to ensure that the people do not, get into challenges. Okay, let's go ahead. So the justice sector response to the pandemic. As at 30th March 2020, the President of the Federal Republic of Nigeria and about 5 other state governors had made regulations to prevent the spread of COVID-19. As at that same date, the Lagos State House of Assembly passed a bill titled the Emergency Coronavirus Pandemic Bill of Law of 2020. And this was actually signed into the law by the government. So the Lagos State came from a different angle. It was not a regulation. The executive involved the legislature in making a law in this respect. Okay, let's have the next slide. Now, both the federal government and the state governments were within their rights in making the law.
Okay.
Yes?
Can I stop you for a second? There seems to be a problem with the French interpretation.
Okay.
Can anybody else give me feedback on that? Is it a question of audibility? Somebody says we are not understanding the French interpretation. So I'm not too sure whether it is a technical problem or a language problem. Somebody's saying it's muted. The French interpretation is muted. Can we try again, please? Okay, continue and let's see how it
just
goes.
A moment, Lucas.
Sorry? Yes.
Look at this is Ben, the French to English, English to French interpreter. I think our other interpreter, Eric, has got some problems I can't really understand because we are not in the same room. I've just asked him to stop, then he continue interpreting to French. It looks like maybe he's not having the right link. I don't know what's happening with this microphone. I can't really understand. He's not able to go to English. He's not able to go to French.
Okay, but can you provide the service then?
Yes, that's why I've just stopped him to continue again with French. So I'm going back to the French channel again.
Okay. Thank you.
So the speaker can continue.
Yes, thank you. Ugechi, continue, please.
Okay, I hope I still have my time. All right, I was trying to say that both the federal and the state governments were within their rights, you know, as provided by the Constitution of the Federal Republic of Nigeria, to make regulations and laws regarding the protection of people during the pandemic. And I have provided the sections of the law for that. Okay, let's take the next slide. Now, the federal and state executives and legislature made the COVID-19 regulations and laws pursuant to an existing Quarantine Act of 2004. Now look at Section 4 of the Act. It provides that the president may make regulations for all or any of the following purposes: preventing the spread of any dangerous infectious disease from within Nigeria, whether an infected local area or not, to any other place in Nigeria. And D, preventing the transmission of any dangerous disease. So the laws that were made within that period were actually in line with the Quarantine Act. But where we have the challenge, can we have the next slide? Can we have the next slide? Where we have challenge is with the punishment section, which raised a lot of concerns. Section 5 of the Act on penalties provides that any person contravening any of the regulations made pursuant to the Quarantine Act is liable to a fine of 200 naira, which is okay going by our economy now. But the challenging aspect is the term imprisonment for a term of 6 months. So the Akwa Ibom state, regulations followed this same Quarantine Act to say that the punishment would be in line with the provisions of the Quarantine Act, which means within that period, there was tendency of somebody being convicted and sentenced to imprisonment for 6 months. So let's see what the laws we have and what civil society organizations did, to ensure that this did not happen. Let's take the other slide. Okay, Lagos equally provided for a fine of 100,000 naira, which is close to $300. And this is big money. big money for maybe a petty offender, big money for somebody, a petty trader that struggles to put food on his table. So this had serious implications. Okay, let's take the next slide. Now, major concerns of the regulations and laws made are that they restrict some of the fundamental human rights of the citizens. That is, although it was still in order because the rights are not absolute, but we find out that these are rights, that people used to enjoy, move out to buy things, move out to do one business or the other to put food on the table, but all these were, taken away abruptly. Now, the people that felt this most were the poor masses, the vulnerable, who could not meet up with their economic and social needs within the period. Now, it took away the activities these people engage in to put food on their table. And most importantly, it was a huge setback in the campaign for decriminalization of petty offenses, as within that period, more offenses in that within that range were created. Okay. Now, custodial centers equally in line with the protocols, the health protocols, were stopped receiving inmates. We had challenges with police cells getting congested. Now, the regulations, the punishments that have been identified in the regulations now conflict existing laws, like we have in our Administration of Criminal Justice Act and the new Nigerian Correctional Service Act of 2019, which made provision for non-custodial measures. Okay, can we have the next slide? Now, in terms of enforcement, a lot of issues were raised. Issues around access to justice, inequality, segregation, and discriminatory application of the laws. At the point the lockdown regulation was made, some people had billions in their accounts. Some others had food stacked in their homes. And everybody, including the ones that never had maybe a cube of sugar in their home or 1 naira in their account, were equally locked down together. So you now start wondering how these people would exist within, survive within the period. There were a lot of human rights abuse, gender-based, sexual and gender-based violence, several was reported. There was torture, inhuman and degrading treatment, and extrajudicial killing. In fact, within 1 month of the lockdown, about 18 persons had been killed extrajudicially. Then in terms of human rights, abuse, torture, inhuman and degrading treatments, we saw videos of persons that were asked to swim inside slimy gutters. Okay, now, okay, let's run. So at that point, what was able to help was the fact that there was non-custodial measures as already provided. So my organization, can we go? In terms of, okay, those that were, arrested for violating the regulations were taken to mobile courts that were established, but a lot of activities happened during that time in terms of advocacy for release of persons in custodial facilities to stop spread, and advocacy to ensure that persons that have committed minor offenses, low-risk offenders, do not enter custodial facility. And it worked out. And these non-custodial measures came to our rescue because most courts started giving decisions in the line of this, giving persons that have been found violating the law the community service. In fact, can we go? Within the period, it was recorded in FCT alone, 23,000 persons were sentenced to community service. So this was the very big thing that happened around that period, because I wonder what would have happened if there was no non-custodial measures, legal framework within the country. Okay, let's go. let's go. Okay, so in summary, what did my organization do? We engaged in a lot of advocacy, to the executive, legislature, and the general public on the importance of putting measures in place to ensure that there is no spread of the virus into custodial facilities. We developed memos to ensure human rights crisis does not arise as a result of enforcement and implementation of the regulations. Then the need to release low-risk offenders, development of strategies to address pretrial detention in Nigeria. We developed education materials, question and answer series to address the concerns of the people regarding the justice response at that period. But most importantly, we developed a guidance manual for the operation of the courts within the period of the COVID-19, a guidance manual for non-custodial officers for the supervision of those that have violated the regulation. We equally developed one for the management of the custodial facilities. Now, because the courts had started implementation, we now utilize technology to start training the officers that have been given the responsibility to supervise these people. Now, that was not all that we did. So when after the online training, as at last week, we started physical training, even of all the DCCs, and we have succeeded in training DCCs from the 36 states of the Federation and the FCT, and we have equally started the training of judiciary, and as we speak, I am in one of the correctional institutions, training instructors in those institutions on non-custodial measures. So all these are what Broward did within the period, and our recommendation is that in subsequently, let's take the last listing, we must have strategic responses to issues thrown up within the pandemic period, issues of social support, economic support, data of citizens, human rights issues, and the rest. Then the need to accompany emergency laws with standard operation procedures to guide law enforcement agencies in the implementation of these laws, and funding and providing all necessary resources for the implementation of non-custodial measures in Nigeria. All in all, then the citizens should be equally allowed, given opportunity to participate in making laws that are targeted at their own safety and security. Now, the issue around requisite cushioning effects for citizens in times of emergency, especially the poor, then public enlightenment and awareness on laws and regulations, proper education of law enforcement agents, and use of security agents who in the past have been developed in terms of their capacity in engagement based on human rights, not bringing any other person to go into the field and engage with the people. And above all, we must work towards decriminalization of petty offenses. Thank you. Thank you for the opportunity.
Thank you very much, Getche. Always very interesting to hear from Prawa, who's been around or with us for many years now. The next item on the agenda before we get to the questions and answer session is the Google quiz or Mentimeter, and Joanne is going to speak to us about that. Thank you, Joanne.
Thank you so much, Lucas. Thank you for the insightful and thought-provoking discussions that we've had from our panelists today, and the continued feedback that you're receiving from our participants via the chat section and the Q&A section. As I had earlier on stated, that we will be engaging you, the participants, in a brief quiz to garner your responses on the manner with which your governments are handling or continue to handle the COVID-19 pandemic. As you look on your screen, you will see the English version of the questions. The same will be interpreted into the Portuguese and French languages to enable everyone to participate in this short survey. So Osoro, kindly assist me in setting up the Mentimeter for the participants to give their feedback.
Thank you very much, Joan. To the participants, I kindly request you to go to the following site highlighted here, www.menti.com. You can use your smartphone or your laptop or any device that you're comfortable with. Once you type in this URL, enter the code that is highlighted on the screen, which is 5856143, and then click submit. And this is the screen that you should see. So we could proceed. The first question: kindly rate the action or responses by your government to curb the spread of the COVID-19 virus in relation to human rights enjoyment. As you vote, we are receiving the results real time. So far we have 23 responses, but I can see we are more than 100 in the participants panel. In the respect of time, we could move on to question number 2. Your screen should have changed. And question number 2 is briefly explain your answer or selection above. That is in the previous question. Please keep sending your responses. We have 16 responses so far. Please continue sending in your responses. "27 responses so far. Moving on to the next question. Question number 3. Do you think these measures or responses were determined by law? 36 responses so far. And as you can see, 64% say no, 36% say yes. Continue sending in your responses. Moving on to the next question. Do you think these measures considered the needs of minorities and marginalized groups? Thirty-five responses so far. Don't be left out. Please send your response. Moving on to the next slide. If your answer in the previous question was yes, please indicate how. Okay, moving on to the next slide. In your view, which other alternative regulations could have been used to deal with the pandemic? And in this question, you can list 3 examples. Please continue sending in your responses. We have 15 responses so far. Twenty responses so far. 20. 34 responses so far. "38 responses. Would not like to leave you out. Could wrap up in 30 seconds. Thank you all. That was our last slide. Over to you, John.
Thank you so much for participating in this brief or short survey. It is clearly evident that a majority of us are not satisfied with the manner with which our governments or states are handling or continue to handle the COVID-19 pandemic. With 97% only stating, with 97% of the respondents stating that the measures did not factor in or consider the needs of key populations and minority groups, then this is actually a situation that warrants immediate response. We've noted the feedback from people saying that alternative measures could have been put in place and which could have adequately addressed the manner could have adequately addressed the pandemic, such as ensuring that there was public participation. And one person actually mentioned that the rights and the needs of the minority and key populations are key and therefore should inform the decisions that the states make. And so finalizing this or closing on this survey, I wish to hand over to Lucas, who will then engage our panelists in the question and answer session. And I also wish to remind the participants, feel free to ask questions, feel free to comment as we continue to engage in this insightful conference. Thank you.
Thank you very much. That was very interesting, a very quick survey to gauge our views. I'm going to make a slight adjustment to the program in the sense of, instead of having a question and answer session, I did send a message to the presenters. I hope they all received it. If you haven't received it, you're probably going to get this now as a surprise. But it won't be a big surprise. For the sake of time, can I ask each of you, and ACJR, you'll have to combine your slot because each presenter is getting 3 minutes. If there is something specific, a question that was posted in the chat box in the Q&A that you would like to respond to, or if there's something that you wish to emphasize or comment on, or any other remark that you would like to make, that you would like to bring to the audience's attention. I will give each of you 3 minutes. Shall we start in the same order as we presented, and start with either Janelle or Kristen, or if one of you would want to, I see Commissioner Manuela. Commissioner, we will give you 3 minutes as well, which then gives ACJR time to decide who will respond, or whether they will share their response time, 1.5 minutes each. But if Commissioner Manuela is ready to proceed, is 3 minutes enough, Commissioner?
It's no.
Thank you. Obrigado.
Obrigada, Luca. Obrigada. Estive a ver o chat e há participante que pede a minha apresentação. Então, o que devo fazer é mandar a apresentação para a tradução e vou mandar, provavelmente amanhã já esteja disponível. Amanhã já estará disponível para poder partilhar.
Desculpa.
De resto, muito obrigada a todos. Foi trabalho maravilhoso. Amanhã provavelmente estejamos juntos.
Is the translation coming through?
Can you hear me?
I can hear you.
I'm on the English channel. I'm moving back to Portuguese.
Did you hear the commissioner speak? Can you?
Yes, the commissioner
give a
said
summary briefly.
Yes, I can. Can you hear me?
Yes, I can hear you.
Yes, the commissioner says that by tomorrow you're going to have the translation in English. Those of you, she was particular about the comment on whether it will be translated. Yes, tomorrow you will have it. Besides that, she's just grateful to be here. It was a wonderful meeting and see you tomorrow. That's what she said.
Thank you very much. Commissioner, are you satisfied, ready?
Bastante com as intervenções e as respostas dadas pelos participantes.
Yes, I'm pretty much satisfied with the participation, the great Q&A sessions. Satisfied with that, yes.
Thank you very much. Can we then move over to ACJR, Kristen or Janelle, who is, or both of you?
Thank you, Lucas. So I'm going to deal with one of the issues that came up in the chat box as well regarding the fact that a lot of petty offense violators or violators of COVID-19 minor infractions are now having criminal records, or what measures are governments putting in place to address this? A criminal record will have a lifetime effect on people who are, and specifically on poor and marginalized communities and people that will impact them worse. And in one of the South African Minister of Justice had a parliamentary briefing in which he addressed the issue of the criminalization of for lockdown regulations. And in that portfolio committee meeting, he addressed the fact that they will be introducing a bill into Parliament to ensure that people with certain who violated certain regulations do not receive a criminal record, but we're not sure when this will take place and how it will look like. And we would want to promote the decriminalization of such violations. So we would really like to appeal to the African states and to the African Commission to appeal to states to ensure that these minor infractions, that people don't have criminal offences or records for such violations. So that's very important to us. And I'm going to hand over to my colleague Janelle, who will address another issue.
Thank you, Kristen. I just want to respond to a question that came in the chat box with regards to the police basically just enforcing legitimate government regulations and questions about whether it is unreasonable for them to do so. In my view, I think what's important to highlight, just as the court did, was that not all the regulations were bad and not all the regulations were good. And I think the important issue here, particularly for poor and marginalized people, is that The problem is that those who are vulnerable are often negatively affected by these regulations, and the consequences of fines or detention further place them in a disadvantaged position. Issues such as overcrowding and unsanitary conditions, as we discussed, those are breeding grounds, and police do have a duty to enforce regulations, yes. However, a human rights approach is crucial, and that is what we are asking for. We don't think that a criminal justice approach is an appropriate response to a public health crisis. I just wish to elaborate again with regards to the documents, the Google documents that was spoken about earlier on. We would like to get your inputs to this document, which will be a statement to the ACHPR. So we're going to put it in the link, and we would like to encourage everyone to participate in the statement that we want to make. Thank you.
Thank you very much, Janelle and Kristen, for those responses. Raghib Zouawi.
Yes.
Please proceed.
Thank you. J'aimerais répondre à deux questions.
First of all, I would like to answer two questions that were asked to me on the chat box. Number one is on the discovery of a vaccine for COVID-19. There's a question who was asking, in case we find a vaccine, what will you do with all the legislation that was developed during the COVID-19 crisis? I could answer that question by saying that since this legislation is special, it will not do any harm to anyone if it remains inactive. However, if we are going to face a fresh pandemic or a fresh outbreak of COVID-19, this legislation will serve first as a foundation to be able to risk the spread of the epidemic, and two, to enable the development of new laws that will be respectful of human rights and less repressive, so that we do not make the same mistakes from the past, both at a theoretical and a legislative perspective. The second question that I want to answer, it was about how can human rights be used to update and strengthen our action plan for protecting human rights. In the case of Tunisia, which is very particular, we can say that the first measures to take first is institutional strengthening, that is the setting up of the Constitutional Court. It is inadmissible that 6 years after the promulgation of the Constitution, we do not have a Constitutional Court that is central and essential for the functioning and the upholding of rule of law on one hand. On the other hand, I think that we need to put an end to the legislation and infra-legislative frameworks that are in contradiction with the existing laws, and also put an end to the punitive laws that are used in a repressive manner and in a unilateral manner from the presidency. We should also put an end to the extended state of emergency, which is not justifiable, and it is a violation of human rights. I would also like to add an element on matters of petty offenses, which is the main theme for this conference. In Tunisia, as soon as possible, we need to adopt a new penal code. We need to take a new approach on these petty offenses, and even to abolish preventive detention as well as imprisonment for petty offenses, because it really amounts to nothing to take someone to imprison someone who's committed a petty offense. And it's not even just good to give them amnesty during a pandemic. Thank you once more. I now hand it over back to you, Mr. Moderator.
Thank you very much. And Julie?
Thank you, Lucas. Thank you to all the presenters and for the participants for your contributions to this discussion. I will address one of the questions that I saw in the chat section that is very relevant is, how do we discuss the culture of defiance and resistance to government policies and laws? Indeed, this is a great challenge. And as stakeholders, we have engaged the security sector actors towards reforming their practices and policies to be more human rights compliant. We have also used, I would say, the inroads that we have with various criminal justice actors to be able to curb some of these practice. For example, through the Office of the Director of Public Prosecutions, we have now the access to charge guidelines, which have been very useful and will be very useful going forward, because with such guidelines, the mandate of charging a person rests with the Office of the Director of Public Prosecution. And as such, if the police then arbitrarily arrest somebody and bring them before court, then the ODPP has a decision on whether or not to charge this person. So we see that whereas one system may fail, another one may come through. We also have various policies that we could use to circumvent the bad practice within the security sector actors, alternative justice systems, community policing, and really engaging more actors into security. We always have this statement here in Kenya that security is not for the police, security is for all of us. So we need to contribute towards strengthening policies that we have. From the general discussion, I think my takeaway and my closing remarks would be towards governments need to find a way to have more inclusive practices, more inclusive discussions before developing regulations and laws, particularly to ensure that every single law that is enacted and passed considers the impact to the poor, the vulnerable, and the marginalized. We need to also create an upsurge and a need for the various essential requirements of the poor and the vulnerable to be top priority. This is legal aid. This is access to justice, access to courts, reasonable parameters, including also rights to healthcare, right to reasonable healthcare. So yes, we are in the system where we say progressive realization of economic and social cultural rights, but we need to realize this because the future of our people, the future of the African people really depend on some of these rights that are critical to the well-being of people coming into play. So thank you very much, Lucas. Thank you very much, the panelists. I wish therefore to conclude Thank you.
Thank you very much. We'll give the last word to Prava Ogechi.
Okay, thank you, Lucas. I am not responding to any particular question, but I'm just giving a little takeaway. One of those is a lot of social issues were thrown up by the pandemic. And my thought is that as Africa, as a continent, we should start reviewing issues around economic, social, and cultural rights. Because of the position we give that in our constitutions, we find out that not much is done by the government to provide social security to the people. I think this is fundamental if we must treat issues of petty offenses or issues arising like the ones that we saw during the pandemic. Now, we equally call for vigilance of all stakeholders. You imagine the outcome of implementation and enforcement of the laws, despite the fact that technology helped us to talk about these issues, to announce them, to predict them. Imagine what would have happened if people were not talking. So as civil society organizations, it's equally important that we are vigilant. We don't allow both executive and legislature to run ahead of us. We must be leading on these issues because we found that quite helpful because it started redirecting the government in terms of releases from custodial facilities, in terms of adopting the new laws, implementing, even though the system, the platform was not yet set for that. Now, the issue around human rights, there are a lot of trainings of security institutions on human rights, but we find out that when the actual usage of this would arise, I don't think there's recourse to the people that have been, their capacity have been built. So what we are calling on is whenever there is need, we are establishing our joint task force for any form of implementation that will engage the civil society more. Let those people that have received that capacity building be on the lead. And generally, laws, we are still calling, we are still making the move about decriminalization of petty offenses. Thank you.
Thank you, Ogechi. And I would like to thank all our panelists for very stimulating and valuable perspectives on the lockdown, petty offenses, and that intersection between different rights agendas. And I think we are facing some significant challenges at the moment where these rights agendas seem to be competing. And sometimes the law is not enforced to the benefit of the people, but quite the opposite. And it's especially poor people who find it difficult to sustain themselves under these difficult circumstances. So with that, I would like to say thank you to our presenters, but also to the organizers for today. We had one or two teething problems, but that is, I think, overall, it went very well. So thank you very much to the organizing people. And I will now hand over to Abdul Nur Mohammed to make some closing remarks. Thank you very much.
Thank you so much. Just as Lucas has said, this has actually been a very engaging and interactive conference. And we've had very mind-blowing discussions on petty offenses and the criminal justice reform agenda. I now wish to invite Edgar Kavalavu, the Program Manager, Human Rights and Justice at ICJ Kenya, to submit the closing remarks on behalf of Abdul Nur Mohammed. Thank you. Welcome, Edgar.
Thank you very much, Joan Mutonga. I hope you can hear me.
Yes, we can hear you.
Thank you very much. My name is Edgar Kavalavu. I work at ICJ Kenya, and I'm going to make brief remarks on behalf of my director, Abdul Nur Mohammed. Indeed, today marks the beginning of a very interesting conference. We are discussing very important human rights issues that touch on rights of citizens in the region. And the decriminalization of petty offenses in the region and its effects have been magnified during this pandemic. I'd like to take this opportunity to thank Commissioner Manuela for agreeing to grace this conference. Commissioner Manuela has been a champion for reforms in the criminal justice system in the continent. I'd also like to thank all the panelists for their enlightening presentations and all our all people who have followed today's discussions and given their input. As I mentioned, this is a very important topic because we all know that laws are designed to protect human rights, but in the event that they are enforced in an arbitrary manner, you find that those who suffer the most are the poor and the vulnerable in our community. So we look forward to tomorrow's presentations. And at the end of this conference, I'm sure that we'll have a lot of fodder to work with in terms of reforming our criminal justice system. As you have seen from the presentations in the various regions in Africa, you find that most of these issues are quite similar. At the end of the day, some of the strategies that you're going to employ are going to work across the region. So therefore, it's very important for us to learn various advocacy strategies across borders and to continue with the partnership among the civil society as well as the various states in the region. So then I would like to say a big thank you to everybody, and I look forward to a fruitful conference tomorrow. Thank you very much.